Welcome to the monthly Truck Stop webinar brought to you by the Motor Carriers Insurance Education Foundation. Truck Stops are presented the second Thursday of each month at 2 p.m. Eastern Time. These webinars are open to members of the MCIEF. These webinars are presented as industry updates for information purposes only and do not qualify for state CE credits. If you're seeking state CE credits, we have a number of programs that do that. Please check our website at mcief.org or email us at mcief@mcief.org. If you have any questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar via email. If you have experienced any audio problems, please send us a note in the chat window or call 800-741-4884. We'll attempt to correct the programs as soon as possible. This program also will be posted on our website afterwards for reviewing later or sharing with other people, your insureds or your other staff members. The motor carrier and cannabis. That's another word for marijuana. It's presented by Jay Sabin, who's an attorney out of New Jersey. Jay, talk a little about yourself and tell us about your firm and what's your interest in this area.
Tommy, good day to all our listeners. I've been practicing law for over 30 years, and I'd say I've been involved with drug testing of motor carrier operators since about the inception of the program. I can remember how testing for the DOT started with a drunk subway operator in the mid-1980s in New York City who had a horrible accident, and then he disappeared when it came to post-accident testing. So I've been involved with this a long time. And I got to tell you, Tommy, I start by having the utmost respect for our driver workforce and the professionalism that goes into getting freight to and from and having that operator get home safely at the end of every day. And I also understand how important it is for each one of those drivers, the little bit of impairment, how it can really wreak havoc with that construct of what the person's there to do. I've been general counsel for a motor carrier, sizable one, over 300 power units. So as general counsel and business partner, I also have a full appreciation for just how hard it is to make a buck in this industry and the different challenges that all our motor carriers have. And lastly, but not leastly, Tommy, I've worked with insurance carriers and their claims administrators, TPAs, for decades now. I have a keen appreciation of how important it is to develop a good working relationship with TPAs so that claims are managed and administered in a fashion that makes sense for everyone involved. And without the support of our insurance carriers, there wouldn't be a trucking industry in this country.
Well, yeah, we always say the government is a function of this. You're right. I think you know that my father's a trucker, and I started this whole program trying to let the insurance industry know more about the motor carrier industry for the same thing you're talking about, the respect, to understand their process. And yes, also with evolving court cases and evolving information available by the public to the public for plaintiffs' attorneys, the TPAs and the insurance adjusters need to understand all the ramifications, particularly the one we'll talk about today, as well as the underwriters and some agents, because there is some understanding of this and how the insured looks at these things as it evolves. And we're dealing with an evolving situation in the government and in the public. There's been a lot of press about driver shortage and how the Federal Drug and Alcohol Clearinghouse has contributed to the shortage. The last understanding I have, since it started in January 6, 2020, there's about 125,000 people who are now on the no drive list, and only about 76,000 of those have gone through the return to work on this part of it. So that's a real problem. So tell us your thoughts in this program you have. Tell us where we are on this, Jay. Go ahead.
Well, I want to just underscore exactly what you said, Tommy. A few things. One, this program couldn't be more timely. The world is changing, and the world is changing with respect to, at least our world is changing with respect to cannabis and our relationship with it, our government's relationship with it, and our driver's relationship with it. In respect to, you mentioned about the drug clearinghouse, there was a fascinating piece of data that came out of the drug clearinghouse the other day, that since its inception, only one quarter of the drivers who have had to go through the SAP process have completed it, according to data.
Explain the SBA process.
The SAP process is what's mandated under federal regulation for a driver to be able to return to a safety-sensitive function. Long story short, once there's a positive drug test under FMCSA regulation, that driver can't go back to operating a commercial motor vehicle again until being cleared by a substance abuse professional. And we'll talk about that today, the importance, more so than ever, of developing a streamlined process with an SAP for carriers.
Let me also point out two things in case the audience doesn't understand this. We're not talking about the driver being prohibited to drive, because this is not a function of the MVRs. It doesn't show up in the MVRs. The only time it would show up in the MVRs is if they were impaired when they were stopped, and then that would be on their driver's license. Second thing is commercial motor vehicle. In the case we did here that requires a drug testing, the vehicle 26,001 GVW or larger. So if the GVW is less than that, then they are not on this list. But anybody who employs a driver 26,000 GVW or larger, private or for hire, intra or interstate, must check the clearinghouse to see if that driver has a operational status or not, and then they'll see this thing. Just want to let them know that it doesn't affect their driver's license or what they drive. It's just the 18-wheelers that we're talking about, which is the main focus of the foundation, Jay.
And I want our listeners to write down a date, November 2024. Write that down, listeners, because that's the date when what Tommy said about MVRs is going to change. That's the date when states are going to have to start withdrawing privileges, licensure of commercial motor vehicles based upon data in the drug clearinghouse. So if there's a driver shortage today, and there is, and you know, Tommy, there's a pandemic out there, and I'm not talking about COVID, I'm talking about the pandemic of quitting. So if there's a pandemic of quitting today, come November 2024, it's only going to get a lot worse.
Now that would affect 26,001 GVW or 10,001 Jay when that happened.
Well, it's only data from the drug clearinghouse.
Okay, so what you're saying is that now, right now, it doesn't affect your driver's license. They could drive, but once they've done that, they will downgrade their driver's license from interstate driver's license to an intrastate driver's license, or from instead of class 1 to a class 2.
That's exactly right, November 2024.
So
that date's in front of us.
So even though now they're not, right now, if you're not an employee or an owner-operator, you don't have to clear yourself, or you might not clear yourself on this. This then would affect even the owner-operators who are driving their own vehicles, who didn't check their clearinghouse or don't have an obligation to. That's the point you're making here. And that's February 2024, right?
That's the date that's been penciled in by the FMCSA. That's exactly right.
Thank you. And let's go ahead then. Next slide then, Jay.
So we talked about the clearinghouse data. Here's another interesting point from the clearinghouse data. Over half of the positive drug tests, and remember there's 6 drugs on the panel, over half of the positives are cannabis. So over half of the positive. Now, that doesn't mean that that test is more accurate than the test for heroin or PCP or cocaine. Rather, it means that our drivers are using cannabis. Our drivers are using cannabis, and we're going to go through that today so everyone's on the same page about just how prevalent the use of cannabis is. And then we're going to come back talking about what that means for the industry and the insurance carriers and our drivers. I'm just going to jump down to some more interesting data about how common it is, how the world has changed. According to the Center for Behavioral Health Statistics and Quality, that's a federal agency. According to their 2019 data, 35% of adults between the ages of 18 and 25 used cannabis within the past year. 35%. So new drivers, now whether that's age 21 or younger, but even if it's age 21 where it stands now, 1/3 of young adults are using cannabis. And even if you look at adults age 26 and over, it's 15%, according to this statistic. Also, another statistic, again, from 2019, 2020, so it's a little dated, but it's the most recent data that's out there. They have data state by state of the percentage of adults age 18 and older who used cannabis in the past month. And it's anywhere between 10 and 25%. I mean, Tommy, pick a state. I'll be able to tell you exactly what the percent is, but it's absolutely fascinating. Okay, let's go on and talking about how socially accepted cannabis is. It's legal for any use in over 1/3 of the states in our union. It's legal for any use in over 1/3 of our states in the union. It's legal for medical use in about the other 1/3 of the states. And a lot of times, take Florida, for example, the array of medical reasons for cannabis use, you could, no pun intended, Tommy, you could drive a truck through it. So in Florida, it's pretty easy to get a medical card for cannabis, and it's tantamount to being legal for adult use because of that. And with respect to the 1/3 or so of the states where it's not legal, I will say it's not legal yet. Even in a state like Texas, there is talk at the legislative level to make it legal in some fashion. So
Jay, I think the point you're making is very accurate, but just they're balancing the impairment or the usage of it with the tax revenue generated. So some of the this is some of the states are looking at this, how to do this by balancing the budget on this situation, right? You skipped over slide 8. Was there a reason?
That we're going to talk about impairment, but I wanted to level set about the use of cannabis. And the one thing I didn't mention, Tommy, is whether cannabis is going to be legal at the federal level. And I'm not going to offer an opinion other than saying there is some chance of that.
Let me mention one thing on this slide 7. The problem that he just went through is that the usage of this, but a truck driver will lose their job over this today. If they have, and again, we'll talk a little bit more about exposed to it and how it stays in your system, things like that. And this is a state by state situation, and the federal government to this point, as Jay just alluded to, hasn't done anything at all in this area. You don't want to talk about an impairment now later, or you want, because this is a government rule, it's this impairment part, or you want to move on to another slide, Jay? That's up to you.
Let's talk about testing and impairment. Let's combine the both.
Okay.
So I've now just spent a few minutes talking about how prevalent it is, the use of cannabis. I talked about how legal it is. And now I'm going to talk about the federal government's response so far to this changing social shift. First, prosecution. Yes, it is a crime under federal law to possess cannabis, certainly to move cannabis between state lines. Having said that, there has been in the federal budget for almost 10 years now. It's about 8 years. The same provision that no money, no federal money is allocated for the prosecution of cannabis use when that use is legal at the state level. So there isn't federal prosecution. In fact, there's no money allocated for it. So the federal government right now is in idle, let's call it that. And now let's talk about what the FMCSA has done. The FMCSA's position, and here we have it up on the slide, is that testing for cannabis is still mandated. And explaining that the use of cannabis after a positive test was use either pursuant to a medical card or legal under the state law is not an excuse. It will not get in the way of an MRO verifying a positive test for cannabis.
Yeah, MRO is the medical review officer.
That's right.
That's required to look at any test. And the point we're making here is it even says here in the outline, not qualified to drive, but that's the point of the impairment rating. And you know, I was listening to the talk radio show yesterday, Jay, about this discussion, and the driver said, well, I can have a beer tonight, and if I sleep off tomorrow morning, I can drive. But if I've had a joint for the last 30 days, I will end up testing positive. What's the difference? How can they do this? This question of impairment is what it boils down to, is it not? That right now there's no adequate test for that impairment rating, because really the concern with any drug is, are you impaired or not?
That's exactly right. And in our day and age, Tommy, where there are so many things that can impair us, we can be impaired by the use of illegal drugs. We can be impaired by the misuse of prescription drugs. We can be impaired by having a bad day, family stress, misfortune. So we're talking about impairment for the use of cannabis. Cannabis scientifically has an effect on the human body, on the adult body, of about 4 to 6 hours. About 4 to 6 hours. It's very idiosyncratic, meaning two different people, even of the same sex and weight and height, cannabis may have a different effect on each person. Whereas alcohol and its effect on the human body is pure math. How much do you weigh? How much did you imbibe? What was the percent of alcohol in what you imbibed? You run it through the calculator, and there you have impairment. Cannabis is not mathematic like that at all. It's idiosyncratic. Now let's talk about testing. The FMCSA today authorizes only one kind of test. That's test of urine. And the urine test detects the chemical components of cannabis 3 to 67 days after use. Let me say that again, Tommy. When a driver is positive for cannabis, what that means scientifically is that the person had some degree of THC, that's the active component in cannabis, some degree of THC in their body in the past 3 to 67 days.
You might want to point out also, they're talking about when it's in your body, you can, this is like secondary smoke. You don't have to have inhaled yourself, but it could still test positive, as I understand it, Jay, even if you're in a room or your roommate or something was smoking around you, you could end up absorbing it.
Well, our MRO community has had to deal with that issue for some time now. The more recent issue that's like that is a driver who used CBD.
Right.
CBD, they bought it. It's legal in their state. They bought it at a drugstore. They bought it at a Kmart. They bought it at the local 24-hour mart. They used it to rub on their body. They thought it would have a positive effect, a soothing effect, some kind of effect. and that CBD had more THC in it than the person thought, in it than advertised. So that's what we're seeing now. But back to the main point here is urine testing does not test for impairment when it comes to cannabis. Does not test for impairment.
Well, even the alcohol is a breathalyzer too, which is less invasive or less of a problem than the urine part of it too, Jay. That even though alcohol flushes out of your system, as I understand it, that part. All right, we've got this testing thing. We put this slide up here on this November 18th. This is when the states must review the clearinghouse data and VRs. We're already talking about this, correct? This part of it here.
That's right. That's right. That's exactly that date that we talked about before.
Okay. And the greater focus of substance abuse professionals, that's what SAP stands for. That'll be the process involved here. Let's go down the slide then here. So tell us, this is what you just said, 3 to 36 days after use. That's a long time. THC in urine only indicates prior usage. It does. The point you're trying to, the point we have here, and as far as I'm concerned, Jay, is it doesn't show impairment. This is the concern that we have here. This court case that you cite, Skinner versus Roto, tell me why you cited that case.
So a lot of our listeners are going to be understandably surprised that there's a test that doesn't test for impairment. And they may say to themselves, well, how is that? How is our federal government mandating such testing? And that was the question before our U.S. Supreme Court about 30 plus years ago. And the Skinner case involved testing for railway workers, but part of the DOT testing protocol. And the railway workers said to the Supreme Court, same thing we're saying today, Tommy. Hey, this test for cannabis doesn't test for impairment. And the Supreme Court said it's sufficient for the government to require that test if it deters use. And meaning, if the driver knows that he or she or they may be tested and there's consequences for a positive test, there's a deterrent effect. Now, I don't know, Tommy, what our court would do with that today. This was during a time and age where there was more of a focus
You're right.
on drugs. But the fact of the matter is, it's a legitimate government interest for carriers to deter use.
And so the bottom line is on this next slide is there is no reliable test for cannabis impairment. This is what we're getting at. These are a couple of reports that you cited in the material you sent me. You want to talk about these reports that you find on slides 12?
That's right. I mean, the sum and substance is, unless you're professionally trained, or unless the carrier has partnered with someone who's professionally trained, good luck detecting impairment. And even for a professional, there is legal debate, scientific debate about how much impairment can be detected. Now, that doesn't mean don't do anything. And if there's one message that our listeners should take away today, is doing nothing is dangerous. Doing nothing is dangerous on our public highways. Doing nothing is dangerous to our partners who are underwriting insurance policies. Doing nothing and continuing just to fire drivers because they tested positive is dangerous because it's legal risk. Let's talk a little bit about the different tests for our listeners. We've talked about urine. There is a new test
on this slide 13. This is the new oral test, fluid test that there's as you say, there's a rule that on February 28th, a change in this part of it to try to move from oral testing to urine testing. Obviously, when I read the article, Jay, that talked about this, it's obviously far easier tests and far less invasive tests and easier to prove, because now you're getting someone's saliva, which is the same thing that you get the DNA check part of it. This is what's coming out. But is this going to make a difference? Is this going to be closer to impairment like alcohol, where it's out of your system? What's your thought about this?
You have a few factors going for this test. One is it is closer to impairment. It's not a measurement of impairment. It will detect use within the past 24 hours. That's a lot tighter window than with urine testing. Having said that, there is some scientific debate of whether 24 hours is really 24 hours. I've looked at the comments that have been filed with the FMCSA about the proposed rule. I'd say almost uniformly they're in favor of it, but some comments question the 24-hour period. Other comments point out, I'll read to our listeners one right now. It says, quote, oral swab testing is not a perfect gauge of impairment, since THC levels are not clearly correlated with behavioral effects. So that's a comment that's been presented to the FMCSA about it. Another is price point. It's not clear what the price point will be relative to urine testing. It seems there's a consensus that saliva testing should be and will be cheaper than urine testing. The way the proposed rule is written right now is it's up to the carrier, the motor carrier, to decide which type of test to administer, meaning urine or saliva. And I would caution every motor carrier out there to think through that issue clearly. It's not an easy decision, and it shouldn't be driven just by one test being cheaper than the other. You may want, as a motor carrier, to have a test that's closer to impairment, but not exactly. On the other hand, you may want, as a motor carrier, to think through whether you want such a test following an accident. And those are complex questions, and questions that a motor carrier should definitely seek professional advice about. It's not playing checkers, Tommy, it's playing chess.
Yeah, it depends on what the here, but this is a post-crash situation. Of course, they're mandated. We recommend, and I have often, that you don't want to test post-crash unless you have to, and that's with a fatality or getting cited with a tow or an injury part of it. But again, this would be a thing. This will be easier to do, obviously, on the roadside by an officer than it would be on the urine test, where they have to go, and you got a lot between 2 hours and 4 hours for alcohol and 32 hours for other substance. So that would be a post-crash. But there also this rulemaking also addresses the hair testing, and some of the some of the larger motor carriers are pressuring to hair test, because that even goes further than the urine. This goes back to maybe what, a year, 6 months that you'll see it here, just to get it completely out of the system. And this even a step further. Now, right now, the way I understand it, Jay, if you do the hair testing and it ends up positive, you still then have to follow up with a urine test, do you not, to actually report it into the clearinghouse? You might clear that up too. I appreciate that.
Here's my opinion on hair testing. I think it's an idea whose time has passed. I see some press out there in favor of hair testing, that it can detect long-term use, patterns of use. I think that's propaganda, frankly, Tommy, by some of the testing companies. I'm not sure in this day and age why a motor carrier is concerned about someone's long-term use of cannabis. And we're going to get to that next, about the underpinnings for my concern, and it has to do with the legal protections that the driver workforce now have under many state laws with respect to use of cannabis.
How long is this? And this hair testing is part of also this rulemaking, is it not, to discuss both of your about oil and hair testing on this proposed rulemaking?
So the answer is no, it's technically not, Tommy.
Okay.
The FMCSA referenced it. The SAMHSA, you see that on the slide now, has reported favorably on hair testing, but is not right in front of motor carriers today or soon to be under FMCSA regulation.
So you still have to do one of the other two if you're all ifs accepted later, that part. But that is something that's moving through it. And as you said, and everything I read, I think that might be a move. But yet the question is, again, until there's some more definitive court cases and all, there's a gray area. There might be more risk, as you aren't you pointing out, in the oil test than the urine test, just because of the factors that this because it would be a new testing method. Is that your concern if the motor carrier accepts that?
So hair testing is not illegal. It's not illegal, but it doesn't satisfy the obligation under FMCSA regulation. And
Right.
Any motor carrier may be asked, why are you doing testing that looks for long-term use? What's the point of that? The days of saying, well, long-term use means the person is a drug addict, at least with respect to cannabis, those days have come and gone. People use cannabis today for legitimate medical reasons. And all a motor carrier is doing by looking for long-term use is looking for an obligation to have to reasonably accommodate a potentially disabled driver.
Yeah, and that's again, and the concern we have at this point is that I think we not only have to review the oil test and the urine test, as you just pointed out, but we also, I think we need to have a understanding, Jay, because there's other two factors here. A lot of motor carriers have a rule that we do not hire a driver who has failed a drug test. Now, I know you have the screening house, the clearinghouse that would also prohibit them from if they had failed that part, but that could even include the return to work. And so, and then the insurance companies have the same kind of understanding. They don't want anyone who has failed a drug test, and that's a no-no on the underwriting side. But again, now you have the return to work. We have to balance the underwriting understanding of it and also the motor carrier, because now they're adding another equation, because I think they would have to also change their procedure to spell out, are you going to do oil or urine in their standard operating procedures too? Would they not?
That's a perfect point, Tommy. Any motor carrier should have the playbook written out in advance about when and where they're going to use saliva, assuming it's approved, and when and where they're going to use urine. That should not be a decision that gets made ad hoc or, God forbid, at the scene of an accident. That's got to be part of the playbook ahead of time.
So that'd be someone in the firm. Now we move on to, again, there's no reliable test for cannabis impairment. Talk about these other slides that we have here, Jay, if you would.
Yeah, I think for our listeners, this is a critical part of the conversation, because I think our listeners right now are wondering what can be done. Because no one is going to say that cannabis doesn't impair someone. No one is going to say that we should be putting on the road impaired drivers. No one's supportive of that. So the question is, what do you do about this social change? What do you do about the change in the legalization of marijuana? And that's where a lot of proactive employers are doing. They are figuring out what are ways in-house I can develop a proactive impairment assessment program. Now, some are following the guidance for something called a drug recognition expert. I don't want to drown our listeners with initials, but that's a DRE. And a DRE is a program that's been in existence for a while now. I believe it came out of the Sheriff's Department in LA a number of years ago. It is the equivalent of the training of a police officer for testing a driver, a regular driver, a non-commercial motor vehicle driver, for alcohol. You ask the driver to step out of the car, walk on a straight line, touch the nose. So a DRE performs a different array of tests, but the tests are designed to detect cannabis impairment. We could have a whole nother podcast, Tommy, you and I, just about whether DREs are effective. The point of our current podcast is for our listeners to be aware that there are DREs, there's DRE techniques, and for them to consider it. Similarly, there's something called workplace impairment recognition experts. In my home state, for example, the adult cannabis law requires that a workplace impairment recognition expert first assess an employee before the employer administers a drug test. So that's another approach. There are other approaches as well out there. There are some apps that you can put on the phone where each employee runs through a regimen of minor testing for about 60 to 90 seconds every day, develops a baseline, and then on days when the person is out of the baseline of responsiveness, there's an intervention by a safety expert. The safety expert goes to the employee saying, hey, you're out of your baseline today. Is everything all right? And now that's another set of eyes on the person. And it's a lot more, Tommy, than what's currently required by FMCS regulation. What's required is for cause. That's a minimum. We're talking about proactive employers out there doing more than the minimum.
Yeah, and I think that's a good point that we're making here, is that this question of impairment, it can be measured. And what I was thinking about, and we have this part, you don't drug test until you have a reason to drug test. And that would be only when the officers thought you were impaired, is when they would administer that would be on after they do this DRE, or an employer would do their, if they have their in-house part of it, before they then would suggest a for-cause test. This is what we're trying to equate here. Now, what I understand is the officers, do they still do this, or this is why often you might have the driver themselves would have tested negative, but if it's a crash or an inspection that doesn't require a drug testing, post-crash drug testing, and this is why they're not finding these kind of impairments based on the driver driving the vehicle until the crash happens, where a lot of times in the alcohol, they do see that impairment more often, and then we'll have them walk the yellow line and then go to the test. Is that some differences in the way that the two are tested?
So some of these assessments are independent of subsequent testing of urine or blood or saliva or hair. And some are connected or preconditioned for different types of scientifically accepted testing. Our point that we're making to the listeners today is a motor carrier and an insurance carrier underwriting policies for a motor carrier has got to think through whether there should be a proactive regimen, a proactive protocol for impairment assessment apart from just saliva or hair or urine testing.
Or even observation. And I think that comes in the next one, training somebody to recognize this, right? This is a problem, a concern that we have on slide 16.
Yeah, I think an honest evaluation of supervisory training, an honest evaluation of for-cause testing in the workplace is that it really has not succeeded. It's very uncommon for a supervisor, who oftentimes is also the dispatcher responsible for getting the freight out the door, is going to be the person who pulls the driver off the road. And the proactive employer, the proactive motor carrier, is thinking through different ways to test and assess impairment. Because just testing, as we've learned today, just testing is not going to show impairment. just testing is going to have the motor carrier lose a driver for some period of time, if not permanently, from its workforce. And that's for cannabis, of course.
Here, of course, we're talking about for cause or random. That would be the concern that we basically for cause where they test them that way. Yeah, this is getting back to the bottom line. What we're trying to determine is we don't want a driver that's impaired driving a commercial motor vehicle or any vehicle that you want out here. It's just how do you do that? Right now, they're throwing the baby out with the bathwater, are they not? Because it's either one way, it's either you failed or you passed.
That's right. And one additional point on impairment, particularly for our listeners who underwrite insurance or administer accident claims, personal injury claims in particular, is that positive drug test is not to be taken as an opportunity and the only opportunity for settling a case anymore. A decade ago, a positive drug test for cannabis meant to an insurance carrier or a TPA, it was time to settle. With the change in social acceptance of cannabis, you're looking at jurors who probably use it. You're looking at jurors who, if they don't use it, know someone who does use cannabis. In addition, the aha moment of that a positive drug test doesn't mean impairment for cannabis. It just means the person used it within the past 67 days, gives defense counsel an opportunity to exclude that positive drug test from presentation to a jury. That's called an in limine motion. So every carrier can write that down today. In limine motion. It is going to be more common for a judge to exclude that positive drug test than it was in the past. So there's a whole interplay here, Tommy. We're not just talking about drug testing. We're also talking about claim management and underwriting for our listeners.
So we're talking about balancing the driver shortage, but we also have to worry about the post-crash requirement of a drug test. And again, if you don't know this, I hope everybody here who's listening to us know this. If a fatality, your insured has a fatality or a cited or then they have to be drug tested for alcohol within 2 hours, no later than 4. And then also up to substance 32. If there is a code or a injury, then they're cited with a citation, they have to drug test. And those things then come up in court cases, and that's why the plaintiff's attorneys want these records when they have to. And what we're saying here is in a case of marijuana, they might end up failing that, but yet if there's no indication of impairment. And one way, when we talk, Jay, about this is also an advantage, I would think, to have forward cameras and driver view cameras to also add to that defense you're talking about. Because if the forward camera shows the driver did nothing that they wrong, meaning they didn't drift off the roadway, they did this part of it, and also if you have the driver facing, you're actually looking at the driver's action. That would be something that they could also use to get that test not effective in the court case. Would you think that would be added part of this?
Tommy, I can only say good things about Drive Cam, as long as the sound is off.
Well, anyway,
it's not fair to that professional driver to be recorded everything he or she or they says over 8 or 9 or 10 or 11-hour period of on duty. It's also not helpful for providing feedback and guidance, watching what the person does, and combining Drive Cam with the engine data of what the driver's actually been doing.
That's the ELD information that you get through the LDs today for the ECMs. This is something that we're actually talking about on our programs now, about that new data to be able to use that for not only driver training, but verification of how the driver is operating. And that's also relatively new as well as what we're talking about here today. The whole world is evolving, Jay, in a lot of these ways for us all.
Well,
Anyway,
we live in a world, Tommy, of numbers, lots of data, and apparently a fair amount of cannabis as well. So that's the world we're in.
Well, the old story I had is that when I use index, if you thought a reefer was something illegal, then you don't know trucking today. We might not want to talk about that part of it, or we have talked about that part of the day. And this is the employee practice liability.
Tommy, I can't believe you waited 47 minutes to tell your reefer joke. I thought you'd be telling that within the first 10 minutes of the presentation today.
Well, I do that as a teaser, even more than that part of it in that area, along with Bobtail being the bird and Deadhead being Grateful Dead groupies. We got a whole sense of that as I get somebody's attention who doesn't understand trucking. But this is also my concern is employee practice liability, particularly if the driver now has completed that return to work or has a medical problem. Now that's a very delicate balance that we deal with, because now we're taking job actions that might be protected, either the ADA or under the return to work situation where the government says they've met that qualification. Now, if you're a protected class, and that's going to be 50% of our drivers, because all of them are going to be over, or 50% of them are over 50 years of age, this could be a concern.
That's 100% right. And I want to make sure all our listeners are appreciating what Tommy just said. For the motor carrier out there that continues to have a policy of not hiring someone because they tested for cannabis, for the motor carrier that is out there that continues to have a quote unquote zero tolerance policy for a positive cannabis test result, meaning the motor carrier fires the person, those motor carriers are taking on legal risk. They're taking on legal risk. About 6 of our states in this union have laws on the books that explicitly say there can't be any discrimination against an individual, against an employee, solely because they have THC in their system. Meaning, if it was legal under state law to imbibe the cannabis, you can't fire the person just because of a positive test result. Cannot. And what we're going to see is we've already seen some legal cases, and we're going to see a whole lot more with employees contesting their discharge. Then there's a whole host of states that have laws on their book that you have to accommodate a disabled employee, and you can't discriminate against someone because they have a medical cannabis card. And we've already seen some court cases where employers have fired a person because of a positive cannabis drug test result and have been sued for disability discrimination or discrimination based on medical card status holder. And Tommy, the world we're in right now is balkanized on this legal issue. If there's 50 states, there's about 50 different sets of rules. And I'm not even counting Puerto Rico or District of Columbia. So every motor carrier that operates, they have to check each state in which they operate, each state in which they're employing a driver. And this becomes even more complicated, frankly, for our motor carrier community when it comes to owner operators. Because in addition for determining whether or not there's legal risk for firing the person, that motor carrier also has to determine whether or not an owner operator is protected by these laws. So it's a very nuanced, layered, complex set of issues that a motor carrier has to go through when they see a certified positive test result for cannabis.
Suggestion to the agents who listen to this is another reason to sell employee practice liability to your motor carriers. They have this situation often for other retaliation back when you push them too hard and want to do false law, but now we're adding another component to it that's very, it's going to be, particularly for the larger motor carriers, it's going to be really a area that we won't have to be concerned with. You gave us some conclusions. So why don't you walk through this summary that you shared, Jay, as we finish up our talk this morning, or this afternoon, excuse me.
Tommy, take it away.
I'm sorry?
Take it away. You've got the summary for us. We know that drivers are using cannabis. The testing is still required. The testing doesn't mean impairment. We learned, a reminder of that today. Testing can deter use, but when over half the positive drug tests in the clearinghouse are cannabis, its deterrence obviously is not occurring that much. Use is occurring, and that's the reality that we're dealing with today.
And as you mentioned, the state laws have just vacillated, and it's an avalanche coming down, as you said, a jackrabbit changing, but it's movement. It's a tax purpose. And then again, you got the labor. We're excluding people that can drive trucks when we need drivers, which doesn't mean that they can't drive safely. That's the thing that we balance today. And right now, we don't know that answer, but that's something that everybody is talking about in this area.
That's right. And what I want to do for our listeners, and we're going to give everyone an opportunity in the chat room, here are things to do. Every motor carrier should review its disciplinary policy about what that carrier does in response to a positive test result for cannabis. And that's true even if that disciplinary policy has been collectively bargained with a union. You've got to review it. Just because it was good 3 years ago, 5 years ago, 10 years ago, doesn't mean it's good and relevant and smart and prudent and proactive today. 2, every carrier, motor carrier, and frankly, every underwriter working with a motor carrier should consider different ways to assess impairment. Testing standing alone is no longer going to be sufficient. 3, and here's a tip to the motor carrier community, get credit from your underwriter for having a proactive assessment regimen.
That's an assessment of impairment we're talking about, not testing.
Correct. Number 4, develop a streamlined return to work process, working with an SAP. If you have a staffing shortage now, don't exacerbate it, make it better by getting drivers back to work quickly. Particularly the positive test result for cannabis may just mean that the driver speaks with a professional, a substance abuse professional, about using the drug off duty or a week before the test result. Streamline that. Number 5, stay abreast of legal developments and focus on November 2024, when the states are no longer going to be able to provide commercial motor vehicle licenses for individuals who appear in the drug clearinghouse. And number 6, as a takeaway, is partner with your TPA about when to settle accident cases after a positive drug test for cannabis and when to try those cases, and take into account in that conversation the potential for limiting motions, in limine motions, and also how your potential jury pool might view cannabis use.
The other 2 things I would suggest here, not only you would have the rule thing, but they need to look at the hiring standards about a driver. Criteria is not only discipline, do they hire a failed drug test? They need to add something in that part of it too, so they don't violate that rule going in, and then emphasize the advantage of the event recorders, both forward and rear, to show the degree of impairment at crash time, because right now, based on your statistics, there's going to be a high percentage, maybe 20-30% of the drivers driving the highway that might test positive, even though they're not impaired, based on the common use, particularly as we get a younger driving force. Jay, what do you think?
Those are two excellent additions, Tommy. That's exactly right. And I love what you're saying about drive cam and using data as your friend, not your foe.
Jay, I really appreciate this. You reached out to us, and we'll do this again in another arena. But I think this adds a lot to the understanding of this, and we're trying to stay on the leading edge to help our insurers to be able to deal with this as they're struggling putting drivers behind the wheel. Yet we have the drivers and the community doing these other things, and we're in a conflict like that we just need to be aware of. Thank you. Be safe, my friend. We appreciate your time today.
Be safe, be well, and it was my pleasure. Thank you.